Ready, Dan?
Yes.
Okay, I'd like to call the Planning, Environment, and Development Committee meeting of October 7th to order. Roll call. Looks like everybody is here but Mr. Kearns. Minutes for approval.
Make a motion to approve September 2nd.
I'll second it.
Minutes.
Motion by Joe, seconded by Carl. Any discussion regarding the minutes of September 2nd? No discussion. Vote. All those in favor say aye.
Aye.
Opposed? Public comment? Is there anybody here from the public? You want to talk, Adam?
No.
I don't see anybody from the public here.
You guys will get a fair dose of me today.
Okay. Great, we'll move on to members' comments. Any members have comments this morning?
I don't.
No members' comments? We'll move on to new business, presentations, routine consent agenda.
I would say take all three off of that.
Okay, we have a request to take all three off.
7.1, 7.2, and 7.3.
Okay. So, we have no routine consent agenda to vote on them, so we'll move right to 7.1. Resolution adopting the McHenry County 2050 Comprehensive Plan.
That was bold.
Make the motion,
That
I'll
was bold.
second it.
So I'll move.
Okay,
I'll second it.
Carolyn moved, Joe seconded. Discussion.
Yeah, I got a bunch of stuff, but I don't know if Adam, you want me to go first or you want to go first? But it's not bad. We're gonna be out of here today. Which is
What's there to say? I mean, this is a long time coming. You know, I don't have a grand presentation for it, but you know, there's been some changes. Joe, is it perfect? I will answer no. But we're closer. You know, there's been a lot of there's been revisions that were, you know, both driven from this board and then driven from kind of the higher powers, if you will, from the federal level, that to remove what we've been informed that should be removed. You know, the I components that kind of make it polarizing. So the intention is to make this about McHenry County, and so that was the spirit of the revisions that were made, and further to make it more about the unincorporated portions of McHenry County, while still reflecting the need and the importance of the municipality involvement.
Okay. Does anyone have any comments regarding that?
a whole bunch of them. For whatever it's worth, the county didn't pay for all these copies. I made many of them myself, but that's how many copies, plus this one that I've read of this since we started this. So on the draft that we have now, there's things that they're not necessarily changes, but they're things that I think are important to talk about because how it works. My first one would be on page 36, and it's about potentially annexing unincorporated land. And they actually use Hillside Road and Crystal Lake as an example. What the board should be aware of is this. Hillside Road and Crystal Lake, because it developed in the county, acted as a barrier for the town to grow. That's not necessarily a bad thing for most people's consideration, but so you have to understand what you've done. If you annex it, they're going to continue to take steps and continue to grow. That's perfectly fine if that's what you intend to do. But when I saw the hillside, I was like, that's the perfect example of what happens when you don't, when the county develops something as single-family residential, the town doesn't annex it because it's too costly to bring in the sewer lines and the water lines and all the rest of the stuff after the roads are down. You just don't want to do it. And yes, that was done in the 60s and maybe even in the 50s for parts of it. But covered bridge trails, upland acres, all those areas act as a boundary for the town. And for many, many years, this county tried to make boundaries around towns so that we kept unincorporated McHenry County as unincorporated McHenry County. 3.1 on page 36 is exactly the opposite of that. It's okay with me, I just thought people should know the difference. The next one on page 77, We still keep talking about walkable neighborhoods and 15-minute neighborhoods. What I'm going to suggest when we're done with this is that the first thing we look at is chapter objective 3, because we can take every piece of it out. But we're going to pass it as it is now. It's just, it doesn't apply to the county. It makes great sense if you're building a neighborhood in the city of Chicago or even in the city of Crystal Lake or any town you want, but nothing in that is what we would do in unincorporated McHenry County. We're never going to build a walkable neighborhood in unincorporated McHenry County. You're not going to have a grocery store within 15 minutes of walking distance of unincorporated McHenry County. It's not going to happen. But at any rate, it's one chapter. I don't think it makes that much difference. Next place we have it is on it's 1.111. Get the page to it right. Yeah, it is on page 88. Sarah and aggregate mining. What you have to remember about strategic arterial resources or aquifer resources is that is a map of the gravel in McHenry County. We don't acknowledge anywhere in this comprehensive plan that there is a competing interest between the gravel industry and drinking water. Someplace we at least need a paragraph that says, folks, you know, if you mine all the gravel, you will not have any drinking water. If you don't mine any of the gravel, we won't have any roads. So those are competing interests. They're going to compete forever, you know, but we should at least acknowledge that. We don't mention the gravel industry until page 88, but we have a whole chapter on Sarah, and guys, because you have in this plan that both things are good, you're going to be faced with those competing decisions when they come out. And they're going to come out. I don't know when the next gravel pit's coming. I don't have any idea, but there's going to be a day when somebody wants to build another gravel pit. And we are setting ourselves up for a fight because we haven't acknowledged those interests compete. Along that same line, I do have one clear typo for you. The Sarah map on page 121, the key is not consistent with the map. It says there's crosshatches areas are the Sarah aquifers, and there's not a single crosshatch on the whole map. And I think it's supposed to be the lighter or the darker blue, but it's just not there.
Yeah, it is.
And then the other thing I thought was nice was finally on page 135, we talk about Hackmatack. It's the first time we raise it in the whole list. I may have missed it, but I was looking for it. You know, it is a significant use of county resources and area. It's going to be open space forever. And I'm not opposed to it. I just think it probably ought to make something before the end. And other than that, I don't have any changes. And even these, I'm not really worried about changes. I think we can pass this as it is and come back to those 4 or 5 things and maybe make some changes later on. But I am tired of reading it.
I've only read it for 2 years, 3 years now.
Yeah, only 2 or 3 years. but that was where I was at with it.
Okay, anyone else have any comments on it? Earl?
Not on Mr. Godemoller's, but 2 things that get under my skin. Page 113, charging stations. And then we go up to page 148 where we're talking about telling folks what they're going to do and how they're going to do it, building their homes, and we insisting that we want to go green with it. I think we ought to just stay out of it and let the market take effect. But again, those are just things that rub me the wrong way in it.
I can tell you there's not a builder in the world that wants the new energy efficiency codes.
It just rubs me the wrong way.
You know, you can tell they came from DC.
Jurisdictions struggle with it. Yeah.
Go ahead, Jim.
Sorry I'm a little late here, but, and I don't know if Joe brought it up or anything, but when they talk about the Union Pacific Railroad, you know, Huntley, Marengo and all that, you know, Huntley backed out of that last week, and I don't know if you brought that up.
No,
No, we didn't
but
bring it up yet, no.
Maybe that should be changed in there, that Huntley's not participating.
What page was that on, or do you have a page, or? No.
I just remember reading that, I don't have the page though.
While we maybe don't want to note Huntley specifically, I still think that we should aspire to have a station in the county. I think that's the position that the chairman is positioned us to take.
And then there were some updated solar farms also, like on Coin Station Road, that should be added in there, because that's designated in there, I believe, as residential or growth, and that's gonna put a line across that north half for Huntley access.
the Huntley Railroad stuff is on pages 99 through 102.
And I'm sorry, Pete, what did you say, because I missed that? What about the chairman?
Well, of course, I don't want to speak for the chairman, but there's been information exchanged about perhaps modifications to the McHenry County Council of Governments legislative program, which specifically noted Huntley as a location for a station, and rather than specifically noting Huntley, let's just say we still would like to see a station located in McHenry County. Just keep it there.
I mean, they really should put it on Coin Station Road, then it doesn't involve downtown Huntley.
Right.
Or the existing train museum or Marengo or some other,
I told you my thought of that. Between the Conservation District and the Railroad Museum, when they gotta fix those bridges going out that where the Railroad Museum ends, they can't get to Huntley. Railroad Museum could come all the way to Huntley, and if they put a station on Coin Station Road, the Railroad Museum could run a trolley back and forth to Huntley for people, and also go to open up the Conservation District for use too for people. And I still think that ought to be in the plan, but apparently the Conservation District isn't in favor of the Railroad Museum, so.
The Council of Governments Transportation Committee, I believe, is meeting on the 22nd of this month, and I think that there is going to be some proposed language modifications there.
So right now, that property's probably open to be able to get there on Coin Station Road.
So if we let
But there's
this,
housing going just south of it.
Allow that to influence?
let's just leave it kind of vanilla, just say the county.
Got it. Okay.
The reason I bring that up, because that changes, that impacts all those bypasses, the Reed Road extension, Algonquin Road extension, Main Street extension, that affects all of that. So it could promote all of that for us.
Okay, anyone else have anything? So is this something we can move forward today with some of these changes, and Adam's gonna add anything?
Absolutely. I would move it forward, and if there's, changes or corrections. I mean, the one thing's just a typo. We shouldn't be holding this up for that kind of stuff. And if the full board wants to make a change in a paragraph or two, have at it.
That sounds good. I think all of these are manageable. Pretty
Okay.
clear direction or something.
And at the board meeting, you can have a reference to a page number and a red line or something?
Yeah, I will confer with Housel Levine. John Housel will be at the committee of the whole meeting on the 16th.
Okay.
To provide, any additional, if there's any additional feedback or to participate in that conversation. He'll be the first person I share these comments with.
Sounds good. Anyone else have anything? Okay, we go to vote on moving this forward. All those in favor say aye.
Aye.
Opposed? Okay, 7-1's done. Move on to 7-2.
I'll make the motion.
Motion made by Jim, seconded by Paul. And Paul, you had some questions about this possibly, so.
Yeah, so reading through it, it's showing that you have essentially an agreement to 2028. And you can, either party could back out of it within 30 days or give a 30-day notice. But there was just some values to this on the third exhibit. Is this an hourly rate? Is that what for the zoning?
Those would be hourly, correct?
Those are hourly rates?
Yes.
And being that that's, you know, potentially our economic engine going on down there, how does that affect your staff? I mean, you feel like you need to ramp up with?
You know, with the adjustment that we made to personnel after Renee's departure and my assuming the zoning enforcement officer and bringing in another planner, our team's confident that we're going to be able to handle the immediate needs. As we start getting the development in, the city will participate in the large portions like the annexation agreements and you know, the documentation that would be necessary for that. Our big portion would be the reports, which take time, but they're objective. They're based on their ordinance. We have their ordinance. We have what they, if you will, need for us to do the job. The volume at this point, we don't believe will tip us at all, and the volume that they have year to year is nominal. So aside from the 2390 interchanges, when I say the big spike in volume.
If it was the status quo, it's no problem.
No problem, yeah, the feet's way more.
If it picks up because of 2390, good problem.
No problem, right?
Yeah.
Well, that's what I didn't know with the staff that you have. I mean, are you ramping up to, or you just feel like it's gonna be stagnant?
We'll be able to take on what they have currently. And then if 90 and 23 come about, we're confident that there'll be a little change, but it'll be confident, like Pete said, it's a good problem.
Yeah.
We'll be able to participate in that.
This time, you know, Chairman Bueller and Mayor Prophet met a couple weeks ago. Mark Picos was involved as well, and Scott and I. I think they're excited to have our assistance and to be ready, to have this in their back pocket and be ready when things happen. A year from now, that water sewer is going to be down just about to Anthony Road. And I think developers are going to start to see that things are happening, and you know, that's what we hope, right? And so we'll keep our eyes on the ball and not lose track. I don't want to overcommit you, but I think this is again, that would be a good problem to have if Marengo's taking up too much of our time.
And Scott used to be the village administrator in Marengo, so he might actually have some input as to when they're overloading us.
Thank you.
Yeah.
Go ahead, Jim. Get something?
Well, on to Paul's question a little bit to add on, is as the development comes forward, do you see this bogging down our other permit process throughout the rest of the county? That's where my concern is on this whole thing there. And is there anywhere else in the county that we do this with municipalities?
So the first part of the question, do I see it bogging down? I think in the immediate, or say the immediate.
In the immediate,
there's going to be in the,
understand.
you know, day to day, there's going to be some decisions when is this hearing date for Marengo versus the hearing date for us. So we're going to have to plan ahead, and that's something that we're comfortable with. I don't think as we get on plane with that, I don't think that'll be an issue. I think we'll be able to manage that staffing wise. And I already forgot the second part. The second part of the question was.
Anywhere else in the county?
Anywhere else in the county. Not for zoning. Not for zoning, we don't. We do have an IGA for building services with Trout Valley. And then for stormwater, we have the certified communities and the non-certified communities, so there's a little bit of.
Will our ZBA be involved in this at all, in hearings?
No, they have their own plan commission.
Okay, anyone else? Adam, on these per hour wages, is when these guys come to you, are they gonna be looking for some type of estimate of total cost, or you gotta put a bid out to them, or is it just piece by piece?
It's piece by piece. What's in these dollar amounts keeps us balanced, as if they're working on something for an incorporated or working on something for the village or the city. It would be piece by piece. The only thing that we would have to adjust would be their meetings are at night. And so we'll have to, as we talked about planning ahead, that'll be part of what we plan ahead, is how we separate staff for those night meetings. But No, it would be hourly.
Paul?
When we talk hourly, does it have all the burdens on here? Does it have the health, their,
Benefits?
The other fringe benefits.
yeah, is that?
Those are all incorporated,
This is, okay, so someone that makes 9138, that's everything included.
everything.
Okay, Carolyn?
And then just if there's any point at which you feel like something else has come up for the county and then they need something, they obviously, you can say, we don't have time for that.
Right, it would
Right,
have to
you
take,
would
right, I
do
mean,
that.
it would just be like anything else. So right now, with our own workload, we're scheduling hearings that are going 2-3 months out. So we can't even get, if someone comes to us with a perfect application and anxious and ready to go, we really wouldn't be able to accommodate them because we have a backlog right now.
Okay. Anyone else? We'll go to vote. Jim?
Yes.
Carolyn?
Yes.
Joe?
Yes.
Dina?
Yes.
Paul?
Yes.
Carl?
Yes.
And I'll vote yes. 7-2 passed. We'll move on to 7-3. Motion for 7-3.
Sure.
By
Make a
Carl,
motion.
second by Joe. Discussion regarding stormwater easement.
Explain.
Sure. If you put it that way. This is stems from an older violation. When I took over, working with the owner, there was a lot of hesitancy to get them to this point. So that's why if you're looking at the permit, seeing it's an older K file, that's partly the reason why. He also assumed that the violation had disappeared, if you will, until I had brought it up just due to the lack when I transitioned, just picking everything back up. So that's an explanation on the time frame. The explanation for the stormwater, the main improvements that the owner made was in what's called exception area 2 on the plat. The surveyor provided a nice little blow up showing the aerial. So really it's just an increase in impervious area above the 20,000 square feet threshold for detention. There was a little bit of a concern that a lot of that drained to the east where it might impact a neighboring ag structure pole barn there. There were some improvements made along the property line along with the neighbor to help steer that water towards the right-of-way. So really it's just a basic case of just an increase of impervious. We don't see, it's a minimal flood risk, therefore staff would concur with the idea that this would meet the ordinance requirements.
Are those propane tanks in the picture?
No.
What are those?
Are you talking about those?
The white,
Yes, that is, so he runs a cattle operation.
those are rails?
Yes, yes.
I'm
He,
trying to
and
place that, but I can't
the back
place
of
it.
the property, he also kind of maintains a rough conservation area, planting some natives and things like that, so, yeah, not propane tanks.
So you're bringing this to us satisfied that what he's doing is correct now? Is that,
Correct, yeah.
and the neighbor, and I think I read in there that the neighbor's okay with it? And
Um,
they're working together on it?
They work together on that eastern property line. I went out for an inspection. I don't see any reason for concern. It would have to be just a huge storm that would probably give the owner their own issues with something like that.
Okay. Carolyn?
But it's, you said that they go into the right of way?
Correct.
Is that a ditch in that right of way?
Yes.
It's a pretty deep ditch right there, if I remember.
I don't recall, yes. I think it all kind of, if my memory serves me right, goes to the east. There's a huge wetland complex right around to the east of him.
Okay, so it would just flow off, it's not gonna go beyond.
Correct,
it's
yeah.
not gonna-
Paul?
Can you explain to me, I know what impervious is, but, with the building roof lines, that obviously is impervious, but when it gets to the gravel, never understood why, you know, if it was concrete or asphalt, it would just roll off. But you do take some absorption in on the gravel, so would you give it any leniency, or do you just see it as a hard skate the whole way?
Well, so originally I had worked with the owner. He had a photo from 1967 showing some of the original conditions, that it was cattle there, that there was some impervious. So we did sit down and kind of go through that together. Ultimately, for the gravel that we're seeing here, it's compacted. So there's very little void space in there. He uses it for the operations of the farm to bring in trucks and maneuver, and obviously, you know, deliveries, the hay, whatnot. So it is an area that sees a good amount of traffic. I do work with owners to indicate that if you have a gravel area, they can get some borings through there and get a soil surveyor or scientist to give an opinion on the ability for the water to get through that layer. I have no issues calling it pervious. And some owners are trying to take those steps. Others are just their choice, I guess. But I do try to work with them regarding those issues. So it's really the compaction.
The compaction of the gravel. I mean, this is a very common thing that you see in a rural area, and it's like, it's a hardship on the farmer. He's, you know, doesn't want to be working in the mud.
Right.
Right, driving around, but yet he's pigeonholed to X amount of impervious. And I just know it's a hardship for these folks. And there's not a lot of leniency. Like I say, you can get a soil engineer or whatever, but that all costs money. And then it's really just, you're either gonna take this gravel out or you're going to put a detention pond in. So there's not a lot when it comes to stormwater. These folks are really having a hard time with some of the laws that we have. I can respect them, I'm just trying to understand a little bit better.
Yeah, this is one of the exceptions that was through the last major update of the SMO that was written in for these conditions to give them more ability. But you're right, you know, doing a plat of survey like this where you have multiple small areas, that's an added cost too as part of it. So it's something that we're looking to update in the TAC currently to hopefully reduce some of those burdens, provide some more resources related to that.
Okay, Jim, did you have something?
Great segue. How does this affect, would this be affected under the new anticipated changes?
Well,
would this be a conservation easement at that point?
No, we're looking to move away from that requirement. So
why do we want to do it with this one?
The SMO hasn't been updated yet. And at the time when I was working with this gentleman, we weren't at the point where, and again, a lot of those details aren't ironed out yet, so I wouldn't be able to give you a full explanation and breakdown. But when I started with this, and this was ready a couple of months ago, and I had been working with Adam. You guys had a lot of kind of full agendas at the time, and since this was just really paperwork, I had just kindly asked him if he was okay with me postponing it for a couple of meetings before I brought it up. But it was started at a time prior to a lot of, at least to where we're at currently with the ordinance.
So I know it's been dry the last couple seasons and all that, but when we had some of these big rains, is there any complaints from the neighbors that it's flooding their properties?
During rain events, yeah, we get those.
Is there complaints? Is there filed complaints that we've?
Specifically related to what sites? I mean, I'd have to go back and look, but yeah, we do get the.
This site?
To this site?
Yes.
I'm not aware of complaints, no.
And if the new ordinance that they've been discussing in TAC is passed, what would be his alternative?
Well, we would look at it on the basis of would there be any flood risk, and that's where we're looking to develop some tools and potentially with staff's aid.
So we're going to pass this. We don't know if there's a flood risk.
No, in this scenario, part of the risk was again that adjacent property because of the way that the contours were sloped. In looking at the overall property, a lot of this was already impervious with the existing operations. We felt comfortable that if it's, with the changes, everything is going to the right of way, considering still the amount of green space that he has, that it would be a minimal flood risk. In the
I don't remember, how many acres did this involve? Does he own?
He owns 49.418 acres, the majority of which is in the back half. And the problem is that right where all of this drainage is, you know, to take advantage of the back half, a lot of that is not tributary to this front area. And so that's something that we're looking to recognize, to say we're not so concerned about maybe the size, but actually what the boundary is of the immediate tributary area and the impact that would have to adjacent properties. And the new regulations are aimed at almost a spreadsheet-like calculation. You enter in the information and you're looking at what were the flows in the existing conditions, what are the flows in the proposed conditions, is there an increase, is it a minimal increase, to have a more thorough way of indicating what minimal flood risk would be. Obviously, in situations where you're maintaining those flows or reducing them, then that would be a good indicator. If they're being increased, then maybe there's some additional modifications, improvements that could be made without having to, you know, do a survey, go to this conservation easement type components.
So if we don't, in the future, use conservation easements, this is permanent for this particular property if we approve this right now. But if we don't approve it, what you're basically saying is then someone has to run a study about flooding.
So I would require him to hire an engineer, and
So he has to do that. The burden is on him because you say that it might flood. But you don't have any complaints or any instances in the last 20 years that this is, since that farm has been there, you don't have any instances of flooding there forever.
I mean, yes.
But he's got to spend money to do this, to prove you wrong.
Well,
I have a problem with that. And that's the problem why there's opposition to our stormwater ordinance throughout the county in the agriculture area. That's why it's go do it and then beg for forgiveness and hope you don't get caught. That's why a lot of them do what they do, because the cost involved, as Paul quotes on some of these things, for things that really don't make sense. I mean, I can understand if this guy had a runoff with the slightest rain, a runoff that's flooding the neighbors and the neighbors are complaining about it. I could understand us putting this gentleman through this. And that's where I really tied up about this, especially when you're talking about doing away with this exact thing in the future update. So I have an issue with it, but I'll leave it at that and let the rest of the group decide.
But there was an issue with the neighbor if they wouldn't have gotten together and cured it.
If there was an issue with the neighbor, but I don't see it, he's telling me there's no issue, there's been no complaints from the neighbors.
There's no issue because they're working on it together.
they had worked on that eastern property, like as I had brought it up to the current owner, where I noted it appears that that area is basically going to flow directly at their pole barn. And he had told me that he had noted that himself and had worked with his neighbor to put up a berm along that property line. And, you know,
So they resolved it between him and the neighbor, any potential of that? Did anyone shoot elevations of that pole barn to his property?
No, it's based on the 2-foot contour, or the 1-foot contour interval from our LiDAR data that we have. So, no, I did not. It was just a visual inspection that you can see it would flow away at that point. I didn't, We could have an additional requirement, to your point, where he would have to pay additional money to get topography of that area. And, you know, the trigger to all this is the 20,000 square feet, indicating that there could be some potential issues for flooding. The ordinance currently just indicates that the applicant needs to demonstrate to the enforcement officer that there's minimal flood risk.
What work did he do for the 20,000 square feet additional?
It just extra impervious for larger trucks to be able to come in for the cattle.
But it was there
operations.
before, right?
Not all of it was there, no. And there was
So
some
he added
building
to it.
expansions, you're right, there were some building expansions, and it just,
Is it 20,000 square feet if he's have enough acreage there, or is it 27,000 square feet of impervious? What's that rule? I thought that
It's-
rule was, if it was above so many acres, it went up to 27,000. Is that not true?
well, 20,000 is the threshold, and then there's the agricultural exemption where you can go up to 1 acre, as long as you designate where that's going to be.
So how big is this?
This here,
Yeah,
well, altogether, he has designated
2.2
exactly
he's got 2
5%.
acres, which he designated, 2.5.
Yeah,
Okay.
total across everything, he has provided the full 5% designation, whether or not that he wants to change that in the future. But this is often with the current regulations, what ends up happening is people just carve off little chunks here and there, which can be added costs to this type of plat, because you have multiple legal descriptions for each one instead of just one kind of neat, clean area. But the 20,000 square foot trigger is what requires them to take a closer look at it. The ordinance currently just indicates you have to demonstrate to the enforcement officer that there's minimal flood risk. We're looking to provide some parameters to that, so that we can, moving forward, use some simple methods to come to that conclusion. Otherwise, what you're looking at is you're relying on me and my interpretation, and then after I'm gone, the next person, and so on and so forth. And for the municipalities, you're opening the same door, and I don't know that you're gonna get consistency across that wide spectrum. So we do recognize there is an issue, and that's where, again, the details aren't ironed out there yet, but that's where we're trying to trend to make it a consistent process that anyone can follow.
Okay, you okay, Jim? Well, I
Okay.
don't say you're okay, but.
No, I'm not okay with this, the conservation easements, but I've just stated my opposition, but I'm afraid for this person that even though he had worked it out with his neighbor already on the building, there's been no objections or anything. What the hell are we even being involved in this for? And excuse my language, I apologize. I just don't understand some of these things that we do on this, and
That's sort of the big
I'm
picture.
going to
That's the
say
big
right
picture
now,
that
I'm
we're
going to
working on.
abstain from this vote because I am very much too biased on this to vote on this.
Okay,
So
so you're getting into the big picture of what we're working on for future times. We gotta really.
I understand that,
If
but
you can do it,
I'm
vote whatever
thinking
you
about
want.
this gentleman right here. And
But
that's where I'm too biased on this right now to vote on this, so I will abstain from this vote.
Okay,
I'll let it go at that.
Carolyn?
So what triggered it is he added impervious surface.
Yes.
That's what's triggered it, and that's currently how the ordinance works at this point.
Yes, and originally when I had worked with him, that old photo that he found in talking with him, he had put a lot of effort tracking that down from a local library. So I sat down with him and I said, okay, I'll give and take with you. Let's sit down and circle the areas where we can see impervious, and if we can at least agree on that, then let's move forward. And we got to that step, and you know, after some time, I think he spoke with some of the drainage districts and just, you know, local farmers and things like that. So I just told him to take his time and make a decision. And to Jim's point, that's it was an older violation, I would love to close it out, but at the same time, it wasn't something that I felt like, hey, there's immediate risk, we need to correct it, when it's mostly just paperwork to meet the SMO as currently written.
I have a couple questions.
Go ahead, Dan.
You mentioned the SMO changing
Hopefully, yes.
to be what?
Well, it's early stages, but this is one section, the detention thresholds, the mechanisms, what's allowed prior to engineering, prior to not, that whole section we're looking to rework. What we're looking to change it to is currently it's a very static system that says, here's your development area, here's how much you're gonna release from your site, not taking into account existing conditions or how much impervious area that development might create. It could be something small like 20%, you're still stuck with that same amount of release rate. Or it could be something on the high end of 80%, you're still stuck with that release rate. So we're looking to go to a more objective, how much impervious area are you adding, and basing reductions off of that.
And so would that change this position when that language changes?
It would be a different analysis that would say, we would look at the tributary area now and say, here's what's happening in existing conditions. You're adding this much impervious. So it could be adding an additional increase in flow. It could be the same, it could be decreasing it. We don't have that ironed out to where I can then run it on this particular situation to give you with confidence, here's what the results would say to that.
Do you have a timeline in which that might occur?
Well, the TAC is set to meet next Tuesday, where staff took an area where a subdivision was previously being proposed, and we used that as an example to show under the current standards, here's what it would look like. Under the new standards, here's what it would look like, so that they can have some compare and contrast for the pros and cons between the two systems.
Understood. And would that change this from becoming, going to become now a stormwater requirement versus the conservation?
Right, we would do away with the conservation. So the idea would be that you could potentially add as much impervious as you want, as long as you show us that existing versus proposed comparison, that you're potentially not increasing flows. Now, we haven't settled on how much of an increase is it a percentage, or is it you need to keep status quo and try to get a reduction. What this would allow, though, is for him to potentially incorporate some other philosophies to say reduction of impervious, some other methodology. Maybe it's an area that he's not getting a lot of vegetative growth, that he could look to plant something else, maybe farm it like hay, that will help provide and drive down that flows. So it's not necessarily steering people towards conservation area and engineers, but looking to potentially implement other components on their property that might still be beneficial and allow them to use their property how they want to meet those requirements, where the old methodology, it kind of steers you towards a detention basin, really. When you look at all of the guidelines, it goes from you're triggering detention, you need detention, here's the requirements for a detention basin.
Could we postpone this item until?
No. This guy's done what he's supposed to do under the current rules. We're going to vote on it today.
Understood.
I was going to say the same thing, Larry. This guy's been working on this for 20 years. We may change our stormwater ordinance. And if he wants to amend it later on to change it, that's fine, but he needs to get off, out of the fire and be done. And it's great to say we can do all these things in the future. This meets the standards that we currently have. Let him be and let him move on with his life.
Yeah, we don't even have those standards worked out, what's going to be in the future.
I have one last question.
I think Paul wanted something first. Okay. You're
What's
okay,
this
Dan?
costing
I'm
to
done.
him?
Yeah.
What's costing him? Does he have a fine that we're charging him to do this?
No, I will not. I think so I have to be careful here because this had a long history where this particular violation, the previous manager was holding up some of his permits. I have released all of those. And I haven't assessed any new fines or fees or anything like that. So
are there old fines that are dragging forward?
the only time that we have fines is when we send people to court.
Okay.
So because sometimes what happens is previously they end up going to court guilty and then another violation opens up. I haven't looked at the full history to see if he had prior violations that resulted of something like that.
No current fines.
But no current fines or anything that exists. So his costs would be the cost for Vanderstappen that he got. I don't know what.
That he had to pay Vanderstappen.
Correct.
And he's agreed to this.
Yes,
Okay.
he has.
It's gone to the mat.
And I think, but just to bring to you guys some clarity, what we'll probably do when we do revise this is honor all of these existing easements. Anyone that wants to come back in and look at it under the new regulations, we would certainly help them with that. And if they wanted to remove the easement at that point, they could, but I don't think we need to retroactively remove anything that's.
Yeah, I think that's a great idea.
I just had a couple questions. So is it triggering, the 20,000 triggers it, right? But it just so happens to be 5% of this guy's property. Mathematically, it's 5% of it, right?
In this case, that's how potentially it can work out.
Is it or is it, if the property was smaller?
He could still get up to 5% if that helps him increase beyond that 20,000 square feet. Sometimes
Or what about the reverse, if it was only 40 acres? Would you be asking?
So, or let's say it's even something smaller, like 2 acres,
Right.
5% wouldn't give him
20,000.
the 20,000 might be the best.
So 5% is the number, and
Yeah.
then 20,000 triggers detention.
20,000 triggers detention. First exemption is up to 1 acre, regardless of size of your parcel. And then the second exemption is 5% for those larger properties that can take advantage of greater than 1 acre.
Just clarifying, so around the impervious area, you were talking that you're gonna try and come up with new ideas. If it was just grass, and if it was a certain amount of grass that when this water ran off the impervious, is there a square footage of that that you take in consideration? If this guy, he might not have had to put a berm up.
Yes.
Because you have X amount of acres between that impervious and this other building. And there is a rate of recharging the ground, right?
That's the idea. Under the current ordinance, what you're doing is you're just taking the footprint of your development, which in this case for this gentleman would be really his impervious area. So what we're saying is under the new guidelines, we want to take a look at the overall tributary area. Because if it's a large tributary area and some of our initial calculations, if you add 1 acre, maybe even up to 2 acres, you're seeing a very, very minimal increase in flow rates. And it might be a long flow path. It might be 1,000 feet before that water ever reaches a neighboring property. None of that is taken into account under the current codes. That's why we're looking to make that change, to look at more of what are the existing conditions, what's happening there, and then how do the proposed affect what's happening. Is there little to no change? Great, let's move forward. And then that way too, we don't have to worry about a conservation easement because we've put some guardrails there or at least some better direction on how we want that analysis to look like on what minimal risk, flood risk actually means.
Yeah, I just see, if you own 50 acres and you can only put 2.5 acres of impervious, I mean, you're really handcuffing that farmer potentially or whatever. So it just seems under the current laws, it's very difficult to expand or whatever. And
And to your point, I mean, it would depend also on the grading, because you could have a large swath of 80 acres that, because of a ridge line, that 80 doesn't really flow to the other side where you're proposing all your impervious. And so that's why we feel like this is a better approach, because then you're providing protections, but you're also being, you're taking into account, right, that you have this large area before the water gets from point A to point B, it has to go 1,000 feet through cropland, vegetation, et cetera, and you're taking advantage of a lot of those resources to account for flow risks.
One last question, would you take all that into consideration and help the potential farmer, we'll call it at this point, or are you making him go through all that?
So, early level of this, we're looking to provide resources on the website where you could do the work yourself, but also potentially open it up to have almost like our CUP process where someone could apply. Maybe it's twice a month with some set timeframes for a nominal fee to sit down with staff to make sure that they have their numbers right and they're using the resources correctly.
Those are like, we have pre-application meetings for commercial, for conditional use permits. So we'll sit down and go through those kind of unofficially, even before we get to site plan review committee and then ZBA. So we're talking about a similar model for the stormwater to try to get everybody on the same page so they can see all of the options available. So
that's what we're currently working on to iron those details out, like I mentioned. But that's the model approach that we would feel comfortable with in providing that service back to owners so that they're not having to go to an engineer.
Yeah, you got the GIS, and there's maybe a crazy comment, but you have GIS, you also have AI. You can almost put like their impervious in there and see how it affects it.
We're
working
with GIS, who has indicated that there's a potential software out there to help run. I've already given them some examples online of similar features that have this capability, where potentially you go on your site, you click in the middle of your improvement, and it will calculate a tributary area and some other features. So yes, we're looking to make it that easy to use, and make those tools available to anyone, so that someone who is capable, more technology savvy, can go in and use the tools. Someone who's not then can look at that kind of pre-application procedure with some time slots to get some help there.
Good conversation about what's going to happen in the future, but this is for what we have in front of us right now. This gentleman's worked hard to meet what our current standards are. It's okay with our stormwater department. It's okay with his neighbor. It's time to vote. Carolyn?
Yes.
Joe?
Yes.
Carl? Yep. Paul? Dana? Jim?
I'll stick with my abstention, but I will say this.
No, that's
If I
not
had to
abstaining.
vote, if I had to
Abstaining
vote
is
yes,
abstaining.
I will vote yes because of the fear of the retribution toward this gentleman that he'd have to put in detention.
Okay, so your vote is yes?
Yeah.
And I'll vote yes. That moves us on to old business and discussions. TUP'S for temporary entertainment events. Thank you, Stoyan.
Thanks.
Temporary use permits. I will invite our partners from the state's attorney's office, our teammates, as we talked about yesterday.
Yes, we did.
All right.
Let's back up for just a second.
Yeah.
If we're going to have the state's attorney's office speak, whoever wants to speak should come up to the table.
So I can hear you.
I'll
Get more
invite you all
chairs?
up. Yeah.
Thank you. Thank you for being here.
Thank you for inviting us. I think.
Oh, no, this is going to be fun. Okay, back to Adam then. Thank you, guys.
Not yet. Yeah. Let us watch what you're saying.
How much talk about stormwater? Wait till we get to you.
So, Where to begin? Temporary use, temporary entertainment events, specifically rodeos, certainly been a focus this past year. But for us, for this team, it's been of focus probably the last 3 years. And we've made incremental improvements with the UDO, bringing in a couple of different measures that will provide a little bit more, use the term loosely, but control or at least management aspects for these events to achieve our priority, which is public health, welfare, and safety. So we've added at the last round of UDO amendments, we added the EMT ambulance, we added the on-site veterinarian, wayfinding. So they were kind of the streets getting into these were flooded with people, with cars, etc. So those routes are maintained, lighting, and then a healthy amount of communication between law enforcement, state's attorney's office, and then on our side doing the administration. EMA, don't want to forget them as well. So as of late, there's been more focus on one of the animal rights activists in the area and animal cruelty specifically, and how these events present the opportunity for such things. There's that side, our as we administer these permits and complaints come in, then our enforcement branches will take the lead, and that's been so far successful, at least in terms of traction and seeing what those complaints are and making movements towards whether they're criminal or whether they're administrative violations or administrative penalties. So that was kind of the generic overview, but I know there's questions and there's other topics for this team to field.
Okay, do you guys have anything to add before we open it up? Okay.
No, I think that's a great summary of what's transpired up to date.
Okay, if anybody wants to speak, fine. Dina, you were sort of driving this thing. Do you want to start?
Sure. So I understand all of those are in play, with police enforcement, monitoring. The question that I had was, is there opportunity to change the language so that we are allowed the rodeos, but we are excluding these, even with the veterinarian and all of these things? Are we able to write language so that this is not part and parcel of the rodeo? So that the tailing component is not allowed in McHenry County at all?
Well, I think the sheriff's office is going to tell you that it's not allowed, and the same with the state's attorney. It's not allowed. However, to police it is somewhat difficult at this point. Is that correct?
Well, it's my understanding that there was an attempt several years ago. I don't know exactly how long, but there was an attempt to modify the language in the UDO, and I don't know what ended up happening as a result of that, but there was an attempt, what was it, 2-3 years ago? Pardon me? Yeah.
It was a couple years ago.
Yeah.
As of today, there's no language change.
Go ahead. Yeah.
So part of the issue, I think, is when you try to regulate a particular action within a particular event, and I'm not going to claim anywhere near any level of expertise as to what actually happens at the rodeos. I mean, I've done some work for the board in the past, specifically related to the rodeos, and it's a little bit difficult of a concept to try to describe a particular event in a way that doesn't run afoul of, or doesn't run the risk of over-regulating another otherwise lawful action. Does that make sense? So the way, like, we could say that it's on a particular way, well, I don't even want to give an example because it'd probably be a poor one, but that's the risk that we run, right? So if ultimately we have a particular situation where we're trying to regulate a particular action, there's always the risk, depending on, I mean, I could have in my mind what I imagine to be the action that we want to regulate as a county board, But somebody else could look at that and say, well, this completely destroys the entire purpose of the rodeo. And so therefore, we could potentially open ourselves up to a due process challenge, but I think that's, that's just one of those issues. I think ultimately, the mechanism by which we enforce it we're talking about the I can't remember what the name of it is, the tail pole, right? Or something along those lines, right? It's where there's ultimately, like, you rip the tail off the animal, right? Whether or not that's considered illegal under the criminal code versus something that we try to regulate under the UDO, really the enforcement mechanism, in my opinion, would be the criminal aspect of it, right? So, right, which would be already there, right? So given the benefit, the potential benefit for trying to mold language into regulating that particular action, in my opinion, and I open it up to my other colleagues here to disagree with me, I think the potential benefit that we get to try to regulate that particular action is outweighed by the risk that we have from what I described. So I know that I'm kind of speaking in hypotheticals here, but that's the best way that I can describe it without getting into the weeds of what we discussed, or what we already suggested in some capacity.
So what I hear you saying is we are already enforcing law that doesn't allow for the harm to animals, yet there is harm to these animals, right? And so you're saying even with the language, which would be conflicting because
Potentially.
In layman's terms, the suggestion is we continue to enforce these events, whether it be drones and police, so that in the event something like this occurs, then there will be criminal, subsequently potential.
There could be. It's all up to the sheriff's office or the law enforcement agency that would be involved.
I'd say that, that's what we're seeing now. Is that we had an event with issues, and that is exactly where they're headed, is towards criminal charges.
Okay, done?
No, my head's spinning.
Okay, go, I'll come back to you then. Caroline?
Just to tag on to what you're talking about. So, yes, a couple years ago, we did do that, something changed, and so we had that in place. And then we've had some other situations where private security was allowed to come in and serve. That ended up having a problem with one event, when we had the issues going on. So that kind of brought in some of these other things like the, like the EMT and whatever. But there is language that I think that we could be putting into our own ordinance. It may not say you can't do this event, like you can't, like getting into these definitions that you're kind of talking about. But for right now, when somebody violates, if somebody's violating this, it's a year, we could be putting in there, you violate it once and you're not coming back, right? Because this isn't just about, you had a concert without a permit. This is you violated the law by engaging in animal abuse, which is not allowed in Illinois. So we could be writing in more strict consequences for when that happens. And then I would want to also know, all right, so we have all these things in place. I know EMA feels put on the spot. If they approve a plan and it goes haywire, they approve the plan, like the incident, what's it called? The incident plan, incident action plan. Yeah. All right, so they want to know that if they help with that they're actually going to follow that. We had trouble getting a vet who felt that they were there for the steer. They thought they were there for the horses. So maybe there needs to be stronger language about what that is there for, and have those, agreeing up front what they're there for. And then also having something in place that if there is any violation, our sheriff's department is willing to shut it down there and then, and not allow the event to continue on. And I don't know, you understand what I'm saying? Like, there's just certain things in place that.
Yeah. Go ahead.
Is this a specific type of rodeo, or does this just happen on accident that you deglove them, or is there a specific type of
It's a specific type of event in general.
Can you just,
the degloving is an issue with.
Is that done on accident? or on purpose?
It's not the intention, as I understand, it's not the intention. They're trying to take down it's a race to take the pole down at a certain mark.
I would
And if
just
they
say
miss-
though, I'm just gonna stop
Go
you,
for it.
we're speaking in generalities, just so we're all clear, we're not talking about the incident that's.
No, right.
No,
That's it. I'm
no,
just
this is
asking.
Because the crime
I'm not-
aspect of that is gonna focus on intent. So I just wanna be clear that any conversation about intent is not with specifics to that event. So
In general.
that is exactly what the sheriff's gonna be looking at, whether there was intent to commit the act. So
Okay.
that's what their investigation is gonna say, was this intentional? Is there not intent? And then ultimately the criminal charges would come from that if there is intent.
And I would just add that I think we are talking generalities.
Okay.
I'm not speaking to a
I don't know
specific
about
event.
rodeos, that's what I'm
Yeah, no,
asking.
I mean, because we are trying to deal with those general terms that we're supposed to be deciding on. It's not tied to a certain event, just to be clear.
Okay, Carl?
Looking at it like an event, you have the health department come out, they certify, hey, you're good to go, and life goes on. Taking it on with the rodeos where we've stipulated, like you mentioned, Carolyn, you know, we have to have the sheriff notified that you got qualified people to be there for traffic control, you have to have a veterinarian. Is there any way we have a trigger mechanism like the health department, someone comes out and checks the boxes that all of the things that we require are there before they have the operating permit?
With rodeos, it's staged. It's kind of a staged inspection. So we'll conduct the actual inspection of the facility on the day prior. If it's on a Sunday, and then 2 days prior on a Friday. The sheriff's office, they're out there, and in conjunction with the private security, they're verifying that the security plan is maintained, so it's the right security that was presented in the application. And then at that point, those would be the eyes of the ear. So whether it's 4, whether it's 6, whether it's a dozen deputies, they would be the ones that would be out there. You mentioned shutting it down. At that point, that's come up in several conversations, and it becomes a public safety issue with 6, 8, 10, 12 officers, deputies that are out there, and 7, 8, 900 people that are out there.
Who've been drinking.
It's just not doing.
Yeah.
It becomes a safety issue for those officers, for those deputies.
Right.
But yeah, to check, so I wanted to tie that in, but to answer that question, is it done on site with like us as the administrators of those permits? No, it's not. We get a lot of these complaints, these issues, whatever occurred that didn't fit that application, we hear about it on Monday morning.
What about, hey, Mr. Venue, you want to do this, it's going to cost you labor for the guy to come out and check those boxes and give you, your okey-dokey permit to do. I have no problem if they're going to flip the bill to have someone come out like the health department does and inspect everything and said, okay, you're good to go. They're paying for that permit, for that expertise to come out and inspect. Why not us? Put the burden on them to flip the money, to have the permit with all these conditions checked off. And if they don't meet it, sorry, pal, you don't get to have your fun.
You got a response to that?
The only thing I would say is that we may be in the same, if it's us, if it's P&D on that, if we go out there and attend and we see something that's counter to what we had previously approved, we would likely be in that same boat. If a team of deputies with badges and guns couldn't shut it down, I certainly with a badge and a clipboard wouldn't be able to. Certainly we can talk and document it, but that's also where the body cam footage becomes paramount.
But if you're the one holding the permit, they can't start operation until you say, we've complied, here's your permit. If they didn't comply, they have no show.
Well,
But they are
that's easy
compliant.
to say. You've got 700 people standing there that are about to be in an event. And Adam's showing up saying, hey, you guys all gotta leave. That didn't happen.
We have that with our health department when they have a big event. They ain't going
I used to run a
until that.
carnival, I understand, but that doesn't, they can shut down the food line real easy. They can't turn the carnival off. It's not, it just doesn't work. You can't put these guys in that harm's way.
Okay. Jim was asking first here.
A couple questions. In our past discussion of this a couple years ago, did we enter the language that there was to be no tailing events? We did not. Can we enter the language of no tailing events? And if there is a tailing event, can we permanently ban those folks from ever on that property or those individuals who register for that event ever getting a permit again for violating that? Because it's animal cruelty if that's what you're calling it. Can we ban them permanently? Can we put that language in our UDO that says there are absolutely no, because I know we had talked in the past about qualifying sanctioned, what do you call them, the National Rodeo Association, whatever it is, sanctioned events. And if tailing's not a sanctioned event, which I don't believe it is it?
It depends on the rules that they're operating under, actually.
What that group
Well-
is. But the county could put the rules in, you can't have that event.
So I'm talking about official rodeo rules. And that's what kind of made this a little bit I didn't mean
Okay,
to.
so that's the question I'm
But
asking.
this kind of ties into what I was talking about with Ms. Krieger. The answer to the first part of your question is yes, we could try. There is that risk that I was describing from before. Depending on how they, when I say they, the prospective event holder, how do we describe a tailing event? And is there a particular, for lack of a better term, mens rea? Like, is there a recklessness or a negligence or an intentionality to it that would otherwise justify a permanent ban, right? So there has to be a nexus between that. But to answer the first question unequivocally, yes, we could try. But the second part of connecting what happens if, or the enforcement mechanism is something that I feel like unless my colleagues here know the answer off the top of their heads, I think it's something we'd have to look into.
The enforcement has to be future. If they violated that and they had a tailing event, that the enforcement would have to be the future. You no longer are eligible for any permits for those events on that property, or you individual whoever, they're all different organizers of them, I guess. And I'm not saying, I don't object to rodeos. I like rodeos, I don't object to them. But since this is such a problem, my question is, can't we just say we're not, if it's a tailing event, it's forbidden in McHenry County. Done. Any rodeo, sanctioned rodeo or any rodeo, we forbid tailing events. That's what I would like to see. And then my next question is on the opposite side, these folks' legality of, is it legal for these folks to fly these drones over the top of an event like this, over someone's personal private property? Is it, so I can fly an event, he's sunbathed out in the back of his house, he got his own nudist colony or something like that in the back of his backyard, and I'm flying my thing over it. Isn't that an invasion of my property?
Well,
Or his property?
I can tell you that with respect to local governments, there's been lawsuits in the past, and the most recent litigation regarding drones against local governments was approximately 4 years ago, and I'm talking about the United States Supreme Court. I will tell you that there's case law preventing local governments from flying drones less than 400 feet above any property. Now we're talking about drones being flown by private citizens.
It's private citizens.
Right, and so I know that drones, they have to be registered with the FAA, and I don't know the specific height, but I do know that for anyone, private citizen to fly drones, they cannot fly their drones below a certain level. I just don't know. I don't know if it's 400 feet, it might be 500 feet. I don't know if you, okay. So, but there is a distance requirement. So it doesn't prevent private citizens from flying their drones over any airspace. It's just that you can't go below a certain distance.
Okay, that, I just question that.
Well, just if I can add something to that, because I had to do an opinion for another department on something similar to this.
This is why I bring my team.
Ultimately, the issue becomes enforcement, again, because at a certain level, adding to what Laura had indicated, it becomes FAA jurisdiction, so the only enforcement by which local government would have would be to report the violation to the FAA, and then have the FAA do whatever it is that they do.
These people are sending you drone footage saying we're doing this. I mean, that's kind of an admission of guilt right there if they're doing it. Now, so I'll leave that one.
Jim, can I ask you to follow up on that?
Yeah, go ahead.
So what did you say? You said that you would get the FAA, it would have to go back to the FAA to see if the private individual was flying it appropriately?
Right.
Yes.
Okay, and then if they were, does it become admissible? If somebody wanted, if they were to provide
That's a whole
it?
nother.
That's a whole separate.
Sorry.
These are great questions.
Go ahead.
No, I'm glad you asked that. My other question was, or it's not even a question, it's more of a statement. I know these folks that are coming to our meetings and all that and complaining and filing these issues, making the issues out of this. Right now, their issue is the degloving, the tailing event. But their issue is anything in that rodeo. And the next thing, they're gonna send you a video and say that horse's eyes are crossed and we don't want animals to be involved in this rodeo. And it's gonna continue. I just don't know how far we can control this. Other than legality issues or banning a particular event, like the tailing and that. And I don't know if there's anything else we can do or should do.
And I'll say not all events are subject to this. I mean, we've had a one event that has been very successful. That same group has been on site and said, hey, we still don't like it, but now you guys did it as well as we could have asked.
Right. Yeah.
Well,
Just going back to the folks that do come to the meetings, I mean, another thing is they want the animals to be covered, you know, so they're not out in the sun, watered. So that goes back to like what Carl says, is there's a checklist. Is there things, is there watering, you know, devices, is there coverage for these animals?
The tent gets awful hot with the sun shining on it.
Right. So I just want to throw that comment out there that there is more than, on the abuse of the animals, is more than degloving. There's several other items that need to be taken care of too.
Joe?
One of the things that I'm concerned at from a board's perspective is we can say all these things, but you're not going to ultimately shut down somebody without a court case. And you know, if the judge, it's fine to say and put in our orders that one of the ramifications are, you know, if you continue to violate these rules, that we'll ask the court to stop that and to stop letting you have permits. But it's going to be a court case. You're not going to have staff in a position that just said, you know, I don't like you, Paul, you can't have an event. You know,
right.
There's a process. These are money-making events. These are ways some people make their living. You're depriving them of that ability to make a living. So you got to have specific guidelines as to what you're going to do. And it's not going to be quick. I mean, it's just not going to be quick. I mean, you know, you file that case today, you'll be lucky to have it tried a year from now.
And I think we've already found that if we don't want to give a permit to one person, it just comes in a different person's name. So, yeah, go ahead, Carol.
Just one more thing, and that is, because I understand the enforcement and the shutting down. I just, get upset about, you know, some of the things that come out. So I understand that it's not really something that the sheriff's office would be able to do and take an event with 500 people and just say, okay, go home now. You know, that's not gonna happen. But to that point then, it's that I think we have to have a better consequence or something written out that says what we're going to do if it's violated.
And I think to Carl's point, with you do these checklists, but these events are occurring after that kind of process, you know, the longevity of these events, so that it's the checklist, they need it initially, but then hours later, subsequently, they don't. And so, you know, my other concern is if officers are concerned about shutting something like this down, that concerns me as well, right? That if we have that kind of premonition that people will become ungovernable, then what do we do with that? Regardless of animal cruelty or not, it's a safety issue.
Sure, in the sheriff's office, I have every confidence we'll be able to
I have no
to
problem
handle
with the
that.
sheriff's office, I completely, but if that is a concern, I think that we have to look at that as well. Is there a quantity of people limit? Is there, no, I don't know. Do they exceed that?
I think that would be with the other departments, temporary use conditions as well, such as EMA, and which I think some of it is already built in, if I'm.
Yeah, I mean, they'll look at how the first responders would have to respond in various situations and circumstances. You know, that's one of the priorities, or why one of the priorities was wayfinding and getting those ingress and egress paths clear. You know, those decisions need to be made in the moment. Right, the one, go back to a permit that was issued on Lamb Road, and the climate changed, and that was a decision not to shut it down because of those types of circumstances, because of police. You get a different crowd, and maybe it becomes plausible, and it becomes an option that they can execute. But
And I wonder about the drones being, you know, regulatory on feet, but if you're a citizen standing there videotaping it, is that allowed?
On private property by a private citizen?
I mean, you're there for the rodeo.
There's a lot of different elements though that can go into a drone equation though. I mean, again, I hate to put our state's attorneys on the spot just because, I mean, you've got the horizontal aspect. Sorry, I'm somebody who studied it a little bit because I always wanted a communications drone. And I've been told by the state's attorney's office in Lieu, there's a lot of rules that go with that. And again, I mean, you can always put a drone straight up, but there's a lot of regulations on where you are in relation to airports, where you are in relation to different, altitude heights. And also, a drone has a camera on it that's quite powerful that can see quite a ways that way too. So you might be going straight up in a place that's permitted, that's not over somebody's house, that's not over an individual, because there's rules on that too. Sure. And again, you're going straight up, and you might be able to see a good halfway all the way around and be able to zoom in and see, all the pores on somebody's face because your camera is that powerful. So again, there's a lot of factors, a lot of depends, and and asking the state's attorneys to weigh in on a very general situation is a little bit difficult because it puts them on the spot, and having to factor in a lot of different legal pieces to that. So I'm sorry to interrupt, but I just thought I'd put that.
I wasn't asking about the drone. I was asking if a citizen had video of their own taking and was able to submit that video.
They could.
Okay.
Yeah, there's nothing unlawful about that.
That's what I'm asking.
Yeah.
With the
It's just,
exception of the eavesdropping
sorry,
statute. No, that's fine.
and they just can't, it becomes a problem when law enforcement requests a private citizen to do that. But if a private citizen does it on their own and then they volunteer the video to law enforcement, that's not a problem.
That's what I'm asking.
Okay, so how are we gonna draw this to a conclusion? Everybody's got the right idea here, and that we wanna help strengthen, to regulate these type of things. We're looking at you guys to tell us what's legal for some extra language, is that correct, committee?
Yep.
Some extra language, something a little tougher, something a little bit more penal.
That's the word, consequential.
You want the violators to be held to a more consequence.
Yes.
That's some of the things Adam and I have talked about, is some of these guys are just doing the calculation. I'm gonna make X thousands of dollars, I'm gonna pay a fine of X, and
And then
it's an easy decision.
a year and 1 day from now, I can do it again.
Well, they're just put it in a different name, but yeah.
Oh, that's another.
So we need to draw this to a conclusion, Jim. You got a point to make to do this?
Just that, I think consequential, permanent ban, if they do a daily
We'll-
ban. Daily ban, permanent ban, you guys figure out how to do that.
Yeah.
That solves it.
Well, as Joe just said, somehow the property.
And the property,
And the property owner, yes.
not the property, just that property can no
Yeah.
longer be used as a road. If you do it
Right.
that way, they have to build a new road every time.
Right.
That might stop it.
So you got some ideas that hopefully that you guys can kick around and bring back to us. That's the best I got for drawing this to a conclusion.
Understood.
Okay?
We're happy to do it.
Thank you.
But don't go anywhere because you're on the next item.
one.
Okay. So we're gonna go to the one that we've talked about previously also, the zoning. Let's see, the amendments for the solar farms, which we've talked about previous. Dina, you were sort of driving this one too. You wanted to start?
So we were talking about, coming to the county board, having a vote that we don't so choose. And so my concern was that our vote isn't necessarily representative of how we would particularly choose to vote on solar based on state legislation. And so I became curious about, is there a way that it becomes, avoidable to come to the county level, county board vote, since our votes really subsequently aren't as we choose. And so is there a way to meander that and through conversation, it could go from the ZBA with the understanding that the state statutes and language could change at any time. And that in that occurrence, it returns to the county without hesitation.
You want to take on that?
Sure.
Okay.
So just as if I understand your question correctly, you want to have kind of a self-repealing ordinance, right? Something that operates automatically,
No.
because this is a problem if that's the issue, right?
No.
That's not what we're talking
That's
about.
something helpful.
Maybe not even address it.
No, and Dina and I have talked about this, so if I'm far off, let me know. But the concern is we're voting on things that we have no choice on how we vote. Okay, so we have to vote yes, because the state legislature says we have to vote yes. And we'd like to make that into something that it's like getting a housing permit, if I'm gonna build a house. We don't vote on house permits. They go to staff, if they meet the standards, end of discussion. And for solar farms, that's basically where we're at. We only have, if you look at that state statute, we get to look at setbacks and we get to look at some visual barriers. That's it. And after that, if it's zone ag, if it's zone industrial, it goes up. And I just assume we change it instead of being a conditional use permit. It's just allowed use in those areas because that's what they have. And whenever that statute changes, I'd be glad to bring it back and put our conditional use stuff back in place. But right now, I don't understand why we're voting on something that we don't have any option on.
Okay.
And if they've met the setback requirements and they've met, that's a yes, you did it, or no, you didn't. We shouldn't be talking about it.
So I interrupt for a second. Sure. I get to be chairman once in a while.
Yeah, no, that's okay.
This is nothing we haven't talked about before. Everything that just was said has been said. We do have certain members of the county board who want it there, so they can voice their no vote. So just
He looks at me when he says that.
to keep that in consideration. And there's not just one, there's several that have spoke up and want it there so they can voice their no vote and let everybody know that they're against it. Okay, go ahead, I'm sorry.
No, that's okay. That's a little bit, excuse me, that's a little bit different question than what I was anticipating. So I don't have the answer right off the top of my head. I mean, we would be more than willing to research that particular issue unless my team members have a different viewpoint.
There is a hearing requirement.
Right, that's, and I mean, 'cause
Yeah.
that's the only concern that we have. It's just, I don't think it's gonna, because I focused on the last two words that you had. Like there was some immediacy for it to come back to the county board. So that's a concern that we have because we've got to go through the due process, the hearing requirements. And of course, we all know that that takes a little bit of time. So it depends on what your definition of immediacy is. 3 months, that's in the scheme of government movement, that's immediate. So that's.
May I speak, Chairman?
Sure.
Okay. Just so you know something that's going on in the background, the Illinois State Association of Counties has a subcommittee called the Solar and Wind Farm Committee to discuss the loss of county control regarding these zoning matters. Chair Althoff of the Law and Government Committee is actually the chair of that committee too, and I know that she is co-signing a letter with Joe McCoy, their executive director, requesting that one of the provisions of that bill that we have to have a full-blown hearing on these zoning matters just be completely, just take it out, do it administratively, just because county board members can't say no. And that was something that was agreed to by other counties on that particular committee through ISACO. So that might be a way to make it so that different, so that you guys don't have to have, folks, expressing their opinions on these things and not being able to respond to them. So if that's helpful to anybody.
Paul?
So I know I've voted almost the whole time for a yes, because they tell us that if we do majority go no, we could put you guys in a bad position. So there is a lot of people that do want to say no that say yes. So that's one thing. So it's not, I think it would be almost unanimous, but I like it being in the peripheral. I think, like Mr. Kearns likes it, I'd like to know where they're going. And I've asked some of the solar farm people to give us a map of McHenry County and show us where they're permitted, where they're actually on certain properties, what properties actually could become solar farms. They know all this information. They don't want to give it to us. I've talked to these people. It's like, just show us where. I think it would ease a lot of tensions, because right now they're just popping up wherever they can go. And because there's certain ratings in the lines that ComEd has that can carry these different solar farms. And so they know the answers. They know the locations. And I think that's what a lot of people that I talk to about it, they're just concerned it's going in their backyard, whatever. There's no transparency at all. And we don't have no say in it. So that's just my comments on it.
Yeah, I've been getting information from those people. There's a level of competitiveness between them. They don't want their information to go to you so you can cross paths with somebody else. So, Jim, did you have something?
Yeah, basically our 2050 plan is worthless because of these solar farms. Totally blows any planning away to protect prime farmland or anything else. It's worthless because of our state. The lawsuits that are going on right now, presently, do we know the question, where the point they're at? They were supposed to meet pretty quickly. What is your answers that they've dismissed? Or?
No, they have not been dismissed. So they're, I don't know how familiar the group is with respect to the pending Will County cases.
Bring us up to speed, please.
Okay, I will bring you up.
That's why I'm asking that question.
Okay, all right. So there are 3 separate cases that have been filed in the 12th Circuit involving 3 separate solar farms. And I think the group knows that these 3 solar farms, they submitted the application to Will County seeking a special use permit to install the solar energy facilities. And obviously during the permitting process, the local officials and residents, they expressed a number of concerns relating to the proposed solar facilities that conflicted with the existing building development plans and would adversely affect the public welfare in the county. So based on those concerns, the county ended up denying those petitions, and then the plaintiffs sought judicial review, with respect to their 3 individual petitions. So as of today, all three matters, they're essentially consolidated. They still have their three separate cases, but they're on, a similar time frame, and all of the matters have been fully briefed. The court has set several status dates, and every time that the parties come up, the court hasn't ruled on the petitions. So the next status date is set for October 17th. And I don't know if the court is going to have a ruling. I know that this is a significant issue because even in the briefs, the parties acknowledge that these cases are a matter of first impression. So this is something that I think the court is going to, be very, very careful knowing in terms of its ruling, because no matter who loses, it's going to go up further. I mean, that's what we know. So, and I don't know how familiar the group is with respect to the arguments, but I can summarize that for you as well.
Please do.
Okay. So the plaintiffs, the solar farms, they contend that the amendment to the county's code, and we're talking about 5-12020. I don't even know how you. That's how you call it, 12020 or 12,020. But anyway, so that's the statute. And they contend that it should be interpreted as eliminating the county's discretion to deny a special use permit for solar facilities so long as certain specifications are met by the applicants. Okay, so that's kind of like the view that, we're talking about today. The county doesn't have any authority to exercise its will. On the other hand, Will County, they are contending, and I think it's a valid argument, that both the plain language of the statute as amended and the legislative history of the 2023 amendment established that the Illinois counties retain substantial discretion in deciding whether to approve the SUPs for the solar farms. So they acknowledge that while the new amendment forbids counties from excluding solar facilities altogether or imposing requirements that are more restrictive, that's what happened a couple of years ago here, than the objective measures listed in that section, the county contends that nothing in the amended provision precludes counties from continuing to consider the public welfare and orderly building development in deciding whether to approve or deny a particular solar facility SUP. The county contends that the county properly exercised its discretion to deny the applications based on concerns that the proposed solar facilities conflicted with orderly building development in the area and was adverse to the public welfare. The county also contends that the denial of the special use permit applications not only were statutorily authorized, but also were supported by substantial evidence and therefore should be upheld. And then specifically, the county contends that because section 5-12020G expressly authorizes counties to require compliance with other statutory provisions in addition to section 5-12020, it is proper for the county to exercise discretion granted under section 5-12001 for the purpose of deciding whether plaintiffs' proposed solar facilities, 1, would impede orderly development in the area, and 2, negatively affect the general welfare. So that's the two competing arguments. And like I said, I think the court's going to be very careful with this ruling, understanding that it has the potential to go up further on appeal. So.
Okay. But you said that you thought that the county had a good case of some sort?
I'm sorry?
The county had a good cause, good case?
Well, they have a valid argument.
Valid argument? That's
right.
That's a better way to say it.
Yeah, it's not frivolous. I read, of course, I don't have all of the briefs, but Adam was able to obtain one of the briefs that was written by Will County in one of the cases, and it's got legs, let's put it that way.
Yeah, so and not to speak about me personally, there's always a concern when I make that vote about the cost to the county. Should we vote one down and get sued? And whether, we were told before that it was because of state statute, it's indefensible. Why go through the cost of trying to defend that type of a lawsuit? You're telling us a little bit different.
Well, it's just, I understand that I have a predecessor, and I'm not disagreeing.
No, that's fine.
Right,
No, I
okay,
get
it's
it.
just, all I can tell you is that in looking at the brief, and then looking further into the issues, it's a valid argument.
Okay, well, you have the advantage of seeing how this is playing out in another case opposed to your predecessor, so that's big for you, for us. I believe it was.
Let's put it on next month.
I mean, I believe it was recommended by the state's attorney's office previously that we wouldn't put ourselves in a position of being sued, but maybe that's something to be reconsidered.
Well, here's the thing, there's when it comes to litigation, there's always a risk in the county making a decision on these high-profile issues, right? And so the county can take a conservative approach, and that's never a bad thing, right? And then, or the county can be like other counties and take a chance. It depends on the appetite that this county has for litigation, and here's the thing, I am not here to tell the county what to do. That is ultimately up to the county board. All we can do is tell you what the risks are when you take either approach.
Mm-hmm.
Can I also add one more thing too, I think, and I apologize.
Go ahead.
I think one of the differences that we see in the Will County cases is there was a ZBA, I think it was 9-0 denial,
Yes.
unanimous.
Yes.
And they also, the county board went through a different decision-making process, specifically as it relates to the LaSalle factors. It was totally different than what we had in the past here.
That's
I want to
exactly
make
right.
that extremely clear. So this is not under any circumstance the state's attorney saying, hey, by the way, we're now pivoting to give you a different position. That's not the case. The facts are totally different.
They are different.
The facts are totally different compared to the last time. I think maybe, because I was around when we have that position, I think
Right.
that the statute speaks for itself as to what we can and can't do as far as restrictions. But one of the other things that was brought up with that prior case or prior cases where the decision was to vote down a solar farm was to add conditions to the conditional use permit, which is different than what happened here in the Will County case. So I want to make that clear.
And just to piggyback on what Kyle is saying, that's a significant difference. Okay, so what happened in the lawsuit involving McHenry County, it's because of those restrictions that were placed on the solar farms. Here in the Will County cases, what they're doing, and they're recognizing, we've got the amendment in this 2023 statute, or the 2023 amendment, and but it doesn't prevent the county from still evaluating the LaSalle factors and determining whether or not we're going to allow the permit for these solar farms. So that is, thank you, Kyle, that is a huge difference.
That's actually what you're saying, though, is a completely new version of law, because in the past, a conditional use meant you already approved the LaSalle factors for that zoning category.
Okay.
So that's a brand new argument.
Well, that's what
But
the
this
argument is.
This is
there.
what they're
I
doing.
understand.
Yeah,
Okay.
I get it.
That's not what we're saying.
Yeah, right.
That's
This is
what they're saying.
Yes.
Jim?
But this in point, for you when you were there a couple years ago, and I was on a roll that day.
I wasn't calling you out, I hope you understand.
No, I was on a roll that day, and I was the only one who was speaking on a roll, that sometimes you need to go after this instead of just rolling over all the time. And it wasn't directed toward you, but it's directed toward our ZBA, who in their comments make, I gotta vote for this, yes, anyway, so I'm just voting for it. Even though I have all these reasons not to vote for it, I'm gonna vote for it. So if we're gonna do something, we need to, I don't like the idea of giving up a vote on this, But our ZBA needs to understand putting the LaSalle factors and different things into it. We voted on one last month that this was in the Village of Huntley's planning area for future planning, not solar farm, it was in something else. But they didn't object because of the same thing of the county's gonna pass it anyway, so we're not gonna spend our time or effort fighting it. But that's one that, under the LaSalle factors, we should have denied, because it wasn't in the best interest of the village, at the time in their future planning, because now we just cut off their northern move, their northern border. So my feeling is under all this, it needs a whole big discussion with the ZBA also under this. They need to be updated that this is what's going on. Because you sit there, when we interview those folks to appoint them, one of my questions always was, are you willing to fight against the solar farms? And I voted no against several of those guys, because they just were gonna roll over and let them scratch our belly. And I don't agree with that. I agree, you need to fight for something, because this solar farm thing has totally restricted. As for another thing, who made the comment about our law and government signing on to something that I don't agree with on the other board, that we should be signing on to that with the state. Because that's what puts us in more jeopardy.
Just, Carolyn, you got your hand up?
Yeah, I was just gonna, all right, so you gotta get to your point with the ZBA, because they're trying to follow the LaSalle factors, and there's other things that we can maybe take into consideration, which Will County has obviously done. I know the ZBA has been trying to, like they've asked for wetland reports and tree studies. That has delayed a couple of hearings, but ultimately, it's not really gonna change anything, because we don't even have anything in our own ordinance about like a tree ordinance, or what, if there's an old oak growth on a particular property, what kind of mitigation you have to do if you wanna take down a certain number of trees or whatever. We don't have that within. But we also don't have anything in place to find out what, as more and more places, as we're losing more and more places, we're finding that these are coming onto areas, not just farmland, but now it's on old oak growth or near wetlands or whatever, and there's no teeth. There's no way to say, well, why are we doing it there and taking down all these trees? I know some people will argue, well, if it's a private property and they want to build a building, they can take the trees down, so they're not moving it forward at the state level. I'm not completely comfortable going to an administrative process, because I think we do have a reason to be regulating these, and I don't want to give up that fight to figure out that we have a voice and we should be able to say where these goes and what kind of conditions we want to put in. I'm aware that I thought Winnebago was also denying them as well, but I didn't say that ahead of time, so you may not be aware of that. But
I can check into it for you
They
and
have,
and see. Yeah, okay.
They've denied several.
Okay.
So I'm guessing they're probably in litigation too, but so it'd be interesting to see because then my thought was, because I just heard that about a couple weeks ago, and my thought was, well, maybe they're testing the waters about where they feel that they can push back on this law, and to them they're thinking it's worth the effort. I don't know.
I think I'll make one more statement to the state's attorney's
Okay.
office. I believe if something happens, and I'm pretty sure you will after what I'm hearing here, we need to give a full try of defense instead of just saying, coming back to the board and say, you gotta change this. Just like we basically gave up on a lot of things, and now we basically have no control over our zoning usage of our ag properties. If somebody wants to put solar farms on the entire county, we have no control of it right now, because we're not willing to fight for it. And my point is, I believe you guys have to be willing to fight to support us. If we vote no on something, you've got to be willing to give it this to say, we did it. Just say, no, we're not going to do it because you're going to have to pay the fees. when we roll over and you lose. So, that's just my opinion, and I'm saying it, nothing against you personally, but in the past, it hasn't been, I have felt our office has not been willing to support if we voted no for a reason, a valid reason, meaning contamination of soil, meaning flooding, meaning public outcry from municipality or different things, we still vote yes on all of them. And at some point, we should be voting no on some of these because they make no sense where they're putting some of these.
I'm gonna push back a little bit on that,
Push
with
back
all,
all you
with
want.
all due respect. I can tell you that, you know, based on what I've learned with regarding the last lawsuit, again, different facts. I think, in my humble opinion, you know, the advice that was given regarding that particular issue, it was spot on. Okay, and it's just because when the county was instituting more restrictions than what 12.020 required, that was a problem. And so I just want to acknowledge that. In terms of our office going forward, yeah, we will, you know, we, just like with everything the office has done, you know, within the last, you know, decade, whatever, obviously prior to my involvement, they will do whatever is necessary to defend the county board and the county elected officials and the county employees. So we're ready to do that.
Okay, that's another question.
Sure.
That we need to work on. I just go to try to define the question we have right now as a UDO amendment authorizing the ZBA to approve these. I don't know if I said it public or not, but I'm not in the fan of giving up our control on this. I think Jim has said that, Carolyn, I heard that. I know Joe in the past has been, had frustration that we vote on it, but if we're gonna give some direction on whether we're gonna look at amending the UDO to do this, then we sort of gotta get together on this today as a committee.
We're gonna bring the ZBA into it.
Well, let's get through this committee first, and we'll work
What
on
I
it.
would suggest is candidly,
Pardon?
I would suggest to see what happens on October 17th, seriously.
Okay.
And the reason is this, and it's all right, so for at least 20 years, the courts have held that conditional use permits already meet the LaSalle factors when you put a conditional use permit in. All right, so that the LaSalle factors are, so if Will County is successful in saying, guess what, we're gonna overturn that precedent, and we're gonna let us look at conditional use, we're gonna let us look at those LaSalle factors in every case, that's fine, we could go that route. But it's up there for debate. We're gonna find this out, at least as a local level at a county, in 2 weeks. I would say move this to November. It's not gonna make that much difference in the world whether they wait 3 weeks to see if that's possible. If we can go back to LaSalle factors and talk about them, I'd be glad to do that.
Okay.
But that's very different from what the rule has been for many years. And so I hope it works.
What I'm gonna do, I'm gonna see if I can get my hand on, you know, all of the briefs, because like I said, we just have access to one of them, and then we can do a much more, or lack of a better word, a comprehensive analysis of the arguments.
When we were working on the UDO, 10 years ago or 12 years ago, that was one of the things when we were going through the list. If it was a CUP, it's because it met those requirements already. And that's one of the things you decide, is this something that would be allowed to do?
I am comfortable with what Mr. Gadamoller is suggesting. Dina, you sort of started this thing, which is great, good conversation here. Are you comfortable with that?
I'm willing to wait to hear, and I think with also, respect to the zoning board understanding that ruling as well as, it sounds like each case has different circumstances, and so trusting that you'd be able to look at one moving forward and say, this is something we could stand on, or in the past, this isn't where we will win. I think it's wasteful energy at that point to send a loss there. So that's just my personal opinion. I think it's an illusion that we have our voice. We do not have a voice right now. Even though you say no, it doesn't, it's like dust to the wind to me. So I am willing to wait to hear on this ruling since this is.
I don't, with respect to the October 17th date, I don't put too much stock into whether or
I
not.
understand. It may be that you
Yeah.
come back in November and say we're still waiting.
Yeah.
2028.
I mean, but it's been fully briefed for several months, and, so it's just been, every month the court is just setting a status, just, hey, judge, what's going on with the ruling, and so.
But at that point, at our next meeting, you would have possibly have the briefs, have read them, and give us an update, no matter what happens at the court that day.
Sure, we can do that.
Be all right. Give us a little bit more insight on how we want to go about this. I don't think we need to do anything today to say that we're going to be amending the UDO or suggesting that even.
That's
So,
sure.
you guys okay with that?
Yep.
Okay. Anyone else want to put into this? Otherwise, we'll let their state's attorney's office get back to work today. So, thank you very much. Very enlightening.
Send me copies.
Thank you.
I'd love
Appreciate it.
Send me
Thank you,
copies
guys.
whenever you get them. I'd like to
Yeah,
see.
absolutely.
Oh, I have one question. Under ZBA, is the state's attorney in the ZBA zoning hearings? Like you have one in transportation?
No.
Okay, thank you.
Thanks, folks.
So that essentially is moved down the road. Dan, are we still being on film?
Yeah, the team's frozen, no one's.
Okay.
Frozen, but-
I noticed they
I've
have
been sitting with my hands above the table the whole time.
Yeah.
That's a good shot of me there now.
Okay, we're moving on to 10. ZBA hearing officer reports. Looks like we got 5 or 6. We got 6 of them.
Six, yeah, all recommended for approval. Renewal, the Assembly of God is a renewal. We've got a couple of I-1 to R1, that's just one over on Track Industrial. And then we've got a couple of variations. The one solar, I'll highlight that. And then that's over off of Route 23, I believe. But nothing that's controversial or anything over the top.
No.
Okay, I appreciate that
Yeah.
perspective. Everyone is more than able and willing to pitch right in and read all those reports before the meeting. We can do the update on the Nippersink floodplain.
Sure. So, asked to join this for kind of a similar conversation, I'd say, to provide the details of the conversation similar to what we did with the conservation easement. But this one was a little wonky. This was about 1.5 years ago that we actually came to the county board to request to apply for this grant. And it's a pass-through grant, so we encumbered $76,000 plus or minus a little change. And we started it. We had a kickoff meeting up in the area of Nippersink with ISWS and the University of Illinois Extension, and it was $6,000 worth of work that we put into it. And then when the first freeze came about, the federal funding freeze came about, that program stopped. And we got a notice from the state, from IEMA, who would be the local administrators for this, that hey, don't do any work on it because during this period of time when it stopped, you won't be able to get reimbursed. Move forward. We got a notice, hey, it can go again. And then there was another pause about 45 days later that hit the brakes on it, and we actually got a notice that the program was going to, from IEMA, that the program was going to stop. So we started looking around and at what the overall goal for this was, and at the same time, having the discussions about the watershed planning. And as we've started that project to set up the framework for that larger project, we looked at this specific survey and said, maybe it's not a horrible thing that this went away. There would have been some immediate good foundational information that we could have maybe provided or made movement towards maybe floodplain buyouts or something along those lines. But when it came back, and then they said, hey, we will reactivate this project if you still want to go forward. So, all right, that's fine. However, they shortened the deadline. They shortened the deadline to be completed by the end of 2026. It's a 2-year project. That's about 14 months away by the time we got that notice. The risk, and it was questionable whether or not we could achieve it. The risk was if we didn't spend and complete that project and spend all $76,000, if we spent $75,599, whatever it is, and that project wasn't technically complete, we wouldn't get reimbursed at all. So our recommendation is to pull this and not go forward with the project at the feasibility is questionable to complete that project by the end of 2026. And two, the risk is there where we may not be able to recapture all the pass-through money or recapture our reimbursement for that $76,000.
That's what drones are for.
That's what drones are for.
So I don't know how the rest of the committee feels. That makes common sense to me, that we wouldn't worry about going forward with this. If anybody else has any input on it, or one or the other?
I'm fine with what Stan had to say.
Do we need a formal resolution to rescind the previous resolution that said we were going to do this?
Yeah, I think that would be most suitable. I wanted to bring this up while we still had 14 months to try to capture it if we were gung-ho to go forward with it.
Actually, it's June of 2026, so even less time.
June of 2026.
Yeah, the original deadline they indicated was June 18th of this year. Due to the confusion and getting clarification, by the time we realized that we could get an extension, we're now into where we are. That June 18th, 2026 date is the final completion for full reimbursement. So you have to present that your project is complete in order to get full reimbursement.
So I'm a little confused on that.
I'm sorry, yeah, I missed my dates up.
Sorry.
Okay, so is there a possibility that it can get done, we can get reimbursed then? Or?
No, it's even less time. It's June of 2026.
Yeah, so.
Oh, okay.
Yeah, I'm sorry. I had it at the end of June of 2026, so we had.
What's the repercussion that we don't do the project? Obviously, you needed to do the project. Was it to stabilize banks or something like that, or?
No, the background is this was a study on specific structures in the floodplain in the Nippersink Creek area.
Structures like manholes?
No, single family residence.
Oh.
And potentially other structures, there's some municipal type structures that potentially were part of that. And it was to do an assessment to basically score the resiliency to flooding. With that information, that would open up for some grant opportunities. Flooding and damage from flooding is increasing, not decreasing. So even just last year, we had one that came across that was for that exact situation, for someone to retrofit, update, make a repair on their home that potentially could help them become more flood resilient. So this was aimed at.
Yeah, in the past, we've had state grants to buy these properties, take the houses down, because there's continuing to be a flood year after year issue. And that was to identify these properties. So if we did get a grant, correct me if I'm wrong, that we would know which ones to go after first.
Yeah, but this would be not to demolish them, to actually make repairs or improvements to the structures to keep them and make them more flood resilient.
Carolyn, you had
Just the 6,000, so is that something that, like, preliminarily, that you would be able to hang on to in case something were to change and we could use it? I mean, was it like, what did that go toward?
It went towards the initial steps of, so ISWS was preparing a model for all of these different structures to be able to get that information. That data's still there, and we can still partner with them, not only to the Nippersink, but we could potentially do the full Fox with our watershed planning and really expand it. So it's not wasted effort, at least, is the good part. but for this particular case.
Carl, did you have something?
I'm a little confused. Over the last 4 decades, we know the Nippersink like the back of our hand. We wanted to waste $75,000 to say that it floods. We already know where it floods. We know the structures that are there, and we know what we gotta do to fix them.
So when you're
Why
talking.
spend money,
So we can get help paying for it.
Yeah, you gotta
Yeah,
spend
when-
money to get more money.
but we're just taking money with stipulations that we're gonna be told how to do something when we know what we gotta do? Well, keep your money, we can do it cheaper.
This would help
When you
identify.
go apply for a grant, you won't get the grant.
Yeah, this,
When the time comes and we
Well,
want
the
to, and,
insurance.
you know, this house has flooded 6 times in 5 years, you know, stop.
But we know that info.
Well, but
We know it, but then we gotta be able to show it and have a report.
This would
You wanna be,
expedite the
you wanna be
demonstration.
competitive
Yeah.
in that bid and providing that information and some of the metrics to show that if we got some that are flooding really badly, it's gonna come to small margins as to why they would choose our properties on Nippersink versus somewhere else downstate in another similar situation.
But anyway, we're not spending the money, Carl.
Good.
So, well, if we have the
except for
resolution.
now, we can have our rates go up when we do flood
Yeah.
insurance.
So a resolution to rescind,
The resolution from last year,
From last year.
and
You
you can
want
bring
us to make
that.
that, can we do that today?
No,
No.
no, it's good. I think we gotta have it on the agenda for next month, and we'll talk about it a little bit next month again, that'll be fun. So, okay, future topics. I will put in that we're gonna have a resolution to rescind this for future topics.
Got it.
No executive session, anybody, got anything for future topics? Otherwise, a motion to adjourn,
Well,
please.
you're bringing the state's attorney back next month, right?
They said they would come back, yes. Looking at Adam.
Motion to
I'm looking at
adjourn.
Adam.
Yeah,
I'll
I got
second
it.
it.
I'll-
Okay, who said to adjourn? Paul?